And I'm just gonna
Start
look.
from 8 and go up.
I am. You know, it's so funny. I always start at room 8. For some reason, I see better when I start at the last room and work my way up. Then I'm like, there you are. But one time you told me you were in a specific room,
It's because I wasn't publicly visible. That's what it was.
and I was like, she's not in this room. All right, everyone. We had a late start today because we had meetings this morning, but I'm going to call the docket. If you're here, let me know you are here. If you don't respond, I'm going to assume you're not here and a warrant may be issued for your arrest. Brandon Wright. Thank you. Mary Diaz. Ricardo Ramirez. And where is he? Thank you. Brooks is on Zoom, and that's supposed to be a plea. And Norma, if you can call John Pettis.
Yes, and I sent. She has it open over there.
Oh, she does.
All right, thank
Already
you.
got the secondary, I'm just waiting on.
All right, and John Meyer, it's set on the docket at 11:30, but they know to be here this morning for the 2 pretrial motions that you all have. Yes. All right, everyone, please confer. We're starting up our jury trial this afternoon, so we're going to do a hard break at noon. So if anybody's not done, you're going to be reset on another day. See, look, I'm already following our rules. All right, everyone, please confer. And then Ricardo Ramirez, we have the violation report. All right, so I have this motion where they're saying alcohol has been detected, this violation report. Have both parties had a chance to review this?
Yes, Judge.
Yes.
All right, so what are we going to do about this? Or is there concern that this is not a
Judge,
true?
I'm
Positive.
concerned that it's a false positive.
Okay.
If you notice, he blew after that because his windows, he's on both Scram and the PBT device. Or do you have it in? Okay. And he blew after that and there was no issues.
Mhm.
Additionally, Judge, this man has been working his butt off on his recovery.
Mhm.
I actually provided the state last week with some mitigation stuff. He's been going to AA. I really feel like he is not using, if that makes sense.
Mhm.
I feel very confident in that based on our interactions. I made very clear to him at the inception of this case that drinking alcohol could be fatal. This is listed as a second VR.
Mhm.
The first VR was the date of installation,
Yes.
and he called and explained to me that he wasn't using, but had some issues with that too.
Mhm.
Based
Well-
on those things, Judge, I feel like it's a false positive, if that makes sense.
Well, I'm looking at the readings and the readings do appear to be a little bit off state. Have you had a chance to review the readings?
The judge, but I mean,
The readings drop very significantly and they shouldn't have.
He got a battery notice too, day before yesterday, Judge, so I don't know if that ever had anything to do with it.
Okay. All right. So from looking at the readings, there appears to be some issues and there may be issues with the device, but the readings appear to be off. So I do have some concerns that we're not actually alcohol that has been ingested based upon the readings that I'm seeing. What I would suggest is perhaps check with the company,
Mhm.
see if that machine needs to be changed out. And we'll keep an eye on things.
Thank
Is
you.
everyone okay with that?
okay.
Okay.
Judge, of course, I didn't see the VR until I think the 19th.
Mhm.
I would have sent him for an alcohol test had it been within 3 days, as far as when I got notice. That's how confident I feel
All right. And is he on more than one device?
in Judge.
All right. Do we need him on 2 devices?
I'm not aware of this case, Judge. I just, started listening to me.
Okay. All right. If you all can look, I don't understand why he's on 2 devices. I don't think he was on 2 devices with me.
He was, Judge, so he had the date of installation of the in-home. There was was it in-home or in-home?
There's a Bluetooth device, the portable device. There's
I
an
didn't have
issue with that recording on that day, and that's when the scram was installed.
But he's had no issues since that time, since day one to today.
All right, are both parties okay with removing maybe the in-home and keeping scram?
The state is, yeah, state's.
Absolutely.
All right, and I think this, which one is the least expensive one?
The Bluetooth device, the portable device.
But the portable device, they're telling me that's the one that was
I-
causing problems.
Your Honor, if I can speak.
Sure.
I am okay with whatever device to show you that I am in full compliance and that I do not look to mess up again.
Were you-
Throughout this process, it's been education, compliance, and application. Those are the three things that I've used to get through this process, learn about myself, and to show you that I'm in full compliance and looking to not only learn about my situation, but show you that I learned.
Well, I appreciate that you're doing that.
Yes, ma'am.
So both sides, how much is the in-home device for you?
The in-home Bluetooth device is $100 a month. The screen is $320 a month.
So we take the scram off, Judge.
All right, but here's the thing. Y'all were saying that the in-home device, there were some issues with it?
No, the scram, well, early on, but no issues in the past, what is it, 5 or 6 months?
Correct, 6 months.
So
All
far.
right, so the in-home device is significantly cheaper. If they were close, I would say, we'll keep the scram. But State, are you okay with just having the in-home?
Yes.
All right.
And there's, just so the court knows, there's no driving right now, Judge, and we have an affidavit on file.
Okay. And I'll put plus. No driving. All right, so what I'm gonna order then is we'll continue with the in-home device. No alcohol use. And I'll put in here waive fees, but I already know what they're gonna tell me, but I always put waive fees in there. But I'm sure I'll get notice that I'm not allowed to do that. So, and I'm also gonna order the removal of scram and the no driving, which you're already not driving. All right, so we were here on January 22nd and was recalled for today for this. Let me give you all a new date. Oh, we're already set
We
for
got
March
it set in,
7th.
Judge, yes, we're
Oh.
waiting on blood.
All right, is there anything else?
State.
All right, thank you.
Thank you, Judge.
Thanks. Oh, I have a new code book. Thank you. Put my signature in the wrong place. Thank you. Norma. I love the new code book. And they picked a nice green. Yes. This has increased in size though. They really should make this hardback because I read mine a lot and the pages end up falling out. So,
It's 42. I guess, like, it's easy, yeah, I know it's- I just don't know, very close.
I can't believe it's already Wednesday.
She's still. They get divorced, that's military career. But she's higher, so she lives in Virginia. Doesn't have to be 6 to 19. And so you don't have to have people coming in and out. So, and then, so neighbors to find neighbors. He just want to have, yeah, that's what I did. There's some picture of that. Oh, yeah.
All right, Deputy Laura. That book is gonna be finished. Friday, it will be finished.
Someone about that book.
Oh, I'm telling you. And you know, she is, Frida McFadden. She writes some good, she is.
Looks like a little freak. Monday, Friday. I guess that's why it's Wednesday.
Okay.
No, I have that.
All right, I have two more books by her.
Okay, which one? We next.
The Locked Door, and we have The Coworker. I will tell you, I'm torn.
Second order though. Because I used to have one look at the time. I can't get to-
Diana? Are we reading The Locked Door?
What is it about?
It's about,
Just by the titles, I would pick the coworker,
all right, so we're gonna do the coworker.
but I don't know anything about it. I'm just saying by the title, I would pick the coworker.
Oh, well, The Coworker is gonna be great. But Frida McFadden is awesome.
Yeah, it's good.
Sorry.
Probably the entire.
And Norma, the paperwork for Mr. Brooks just came through. All right, thank you. All right, thank you.
Is it Chandler too?
Well, Chandler is the one that opposed it. That it would be. It's a special force, but special division.
See if I know.
Can you just, I just need to see, I want to see if it what court is. I'm not sure.
Yeah. So you put it in the office.
Yes, I got it. 102-102. No, put salt over. Ready? 2015. 168. No, it's 186. Oh, yeah. So I think it's not. Yeah, no problem. Yeah. So is you available for a question or? So. What are you? Yeah, first she got this shirt on there.
Okay, I'm so on it because you're really, I'm invested. Okay, we're doing it. Okay, I'm gonna read it. I've been working on it, so it's gonna happen.
And it took me a while just to get past the title because I was with the jail stuff.
Okay, do you know she has another book called Want to Know a Secret? I don't know, maybe not.
Oh, there's a confusion, so that's the record. And we probably actually don't like. Just so that you know, usually if we haven't been in compliance or something, my go-to is like, I usually just double what it was.
That way I can kind of.
Yeah. So range.
Thanks, Dave.
Unless you picked up on her name.
No, it's all kind of reason. Appreciate it.
See ya.
She sounds friendly. I was. Oh, I'll check with you. I'll just hang on. Thank you. Like basically, I'll do that and I'll
Yeah.
along it. What do you mean? Oh. You know. Oh, it's in your eye. I have watched some. Okay. I've watched a. Which one might confirm? I would never want to go back to. Yeah. It's like so long because it's been all the same all the time.
I don't know if she wanted to try to do it. Right, and it's not to stand
Well, I think he heard it, being like, because then he can apologize. But I'm like,
He's thinking, I don't know. Exactly, it's not back to nothing, no one.
Yeah. Oh, wow.
So he's all happy with this, and your guys still see it in the other county. Yeah.
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 You can't tell me 20.
I'll check on this. Okay. So it has changed. Okay, wow. So this is 2024. Okay. So.
Oh, I mean. Check what I've been doing is I can.
All right, Mr. Brooks, we're waiting for your attorney to zoom in. So I'm going to put you in a breakout room. And a clerk will probably meet with you and go over the paperwork. And so I will send you there. And then the person whose name is Monica, who are you? If you could unmute, please.
Yes, ma'am.
Yes.
Monica.
She's the complainant's mother, judge. She has victim impact statement.
All right, so I'm going to place you in breakout room number 2. And what's your full name, Monica?
Severa, Monica Severa. Last name is spelled Cervera.
All right, so I'm going to put you in breakout room number 2, okay?
Okay.
So as soon as everybody's ready, we'll take those matters up. That's supposed to be a plea. I've already signed the plea paperwork. Okay. All right, so let me bring him out. Oh, you know what I will do? Let me go to that room. I'll be right back. You say the consent form and what else?
Just the. No, I'm thinking two.
So he was over here.
Okay, I'll give you.
It was mostly because of this girl.
Oh, give me attitude.
Remember now?
Yes. I do, yes.
Well enough, well as I'm gonna be. So, that's all I do.
Hello? You have the wrong number. No problem. Thank you, you too. Bye-bye.
Yeah.
All right, could I see the file on Mary Diaz, please? Mary Diaz and Brandon Wright. Yes, please.
Both things.
My lucky day. This one's actually out.
All right, Mary Diaz, if you come forward, please.
Didn't get demoted. Third job.
Mary. All right, this trial is set for January 29th.
Yes, Judge.
Defense is going to be asking for a continuance. And before we go on the record, have you had a chance to review that?
I have not, Judge, but
All right, so let me let you review that
You reach it.
and see if you have any objections. Because I don't know if this case has out-of-state witness or what. I do know I want it tried.
thank you, Judge.
All right. So we're going to go on the record. Court is calling 2020 CR 11865, State of Texas versus Mary Diaz. Can I have parties announced for the record for the state?
Anna Ochoa Nelson.
Defense?
Charles Buck from Ms. Diaz.
And are you Miss Diaz? All right, so the defense has filed a motion for continuance. State, do you have objections?
No objection from the state judge.
All right. So, state, do you have out-of-town witnesses or no?
On Mary Diaz, there, off the top of my head, Judge, I know there's potential to have one or two for records, Your Honor.
All right. So those two witnesses who are out of state for the records, are you saying they're just the custodian or is there something else?
There's the custodians, Judge, right? The discovery on this one is pretty voluminous, Your Honor. So what I'm thinking of or know of off the top of my head would be, at the moment, we need a custodian from Google who would have to come out from California. And I believe they said they needed at least 14 days notice to do that.
All right, so with regards to the person that's the custodian who are just gonna lay the foundation for the records, would you have any objections to them appearing by Zoom?
No, Judge.
All right, so they'll be able to appear by Zoom, custodians.
Yes, Your Honor.
And do you have any records that you need someone to appear by Zoom as well?
No, Judge.
Okay. So let me put him in the waiting room just 1 second. All right, so I'll notate that the defense has no objections to custodians by Zoom. And so maybe that'll help you with the 14 days.
That should help, Your Honor.
And Ms. Diaz, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand, state your name for the record.
Mary Jessie Diaz.
All right, Ms. Diaz, your attorney has stated that he does not have any objection to the custodian of records appearing by Zoom. Do you have any objections to that?
No.
All right, you understand you have a right to have witnesses present in court for your attorney to cross-examine?
Yes.
I'm sorry?
Yes, Your Honor.
All right. So are you giving up that right as it relates to the custodian of the records?
Yes, Your Honor.
Okay. So of course, your attorney will still be able to question the custodian, but the custodian of records will not be physically present on the witness stand, but they will be here by Zoom. Do you understand?
Yes, Your Honor.
All right. Okay, so with regards to this, how long do y'all expect the trial to last?
Judges, from the state's perspective, this is going to be a lengthy one, probably looking at closer to a 2-week trial here.
All right, I'm going to grant the motion for continuance. After this, there will be no further continuances. Ms. Ferguson, on this case, we need a date. They're saying 2 weeks. And so when is family violence up next?
Not like. They're packed.
Okay.
So earliest I can.
That is so, so far away. So what? Deputy Laura, can you mute us for a moment, please?
See when, let me see what my son's graduation is in May. I
Okay.
can't miss that. I leave town on May the 27th, I know.
All right, and then Brandon Wright.
May 11th, not 12th, so as long as we work around that. I'm here.
Run right into that.
But
I
as
don't
long
want
as
you,
we-
I don't want you to miss that.
Well, I'm not gonna miss it, but I mean, even if we just take that Friday off, don't work the 10th. I leave on the 24th. So, yeah.
All right, so Brandon Wright.
There he is.
All right, so counsel, you're asking for an appointment of additional counsel?
Yes.
All right, that'll be granted.
And then we need to get I would like to, while Mr. Wright, as you may or may not remember, Judge, has driven in from Houston to join us.
Yes.
We'd like to see if we can, try to at least get a date for Mr. Wright's trial. Today was his plea deadline date, I believe.
Okay,
And,
yes. And then so,
not reached an agreement, so I think we're going to require a trial.
all right, before we get to that,
I beg your
so
pardon.
no problem. So on your appointment of additional counsel, based upon the rules,
Yes,
they're allowed to be paid for the time that they're in court for trial.
yes.
Okay,
I'll get that name to Norma.
all right, thank you. Now, Mr. Wright,
Yes, Your Honor.
you've had a chance to consider the state's offer,
Yes, Your Honor.
and are you rejecting that offer?
Yes, Your Honor.
All right. So your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, Your Honor.
All right. So how long are we expecting this trial to last?
Sorry, give me a second, Judge.
No
I
problem.
have sorted out which one, this one from the other ones. Yeah, probably 3 days worth of state's testimony, Judge.
All right. And then if you say 3 days, I've seen Mr. Bonk in trial. My mom has seen Mr. Bonk in trial. He asks no questions that are irrelevant. He's always asking just pointed questions. I've seen him cross-examine somebody and ask 3 questions. So
Fair enough, Judge.
when I say 3, I'll give you 3 days, but I think it's probably going to be 3 days for the entirety of the trial. I could be wrong.
That would be great, Judge.
Charles may surprise us all.
I would love it 3 days.
And then my mom will call me, what's going on with Charles? All right, so Norma, on this case, let's do this. We'll bring this back on the same date as Mary Diaz. And at that time, we'll see the lay of the land with their trials. So we'll take that up on the same day. What did I say, the 13th?
12th.
12. Yes,
Would my client be allowed to report to attend that setting by Zoom since he does live in Harris County and Houston?
Yeah. yes. All right.
Okay,
You need to zoom in exactly at 9. All right. Is there anything else?
no judge.
No, Judge.
All right. We'll see you back on the 12th. And it's not a trial date,
Correct.
even though it's on the trial setting. It's just to see what happens with their other cases so we can make a determination of where to put you for the trial.
Yes, Your Honor.
All right. Thank you. Is there anything else?
That's all I have, Judge. Thank
All
you.
right. Thank you. Can I have the Mary Diaz file back? I need to make a notation or something. All right, thank you.
I'll check it out.
Where did Robert Porter go?
Right here you are.
Hi, oh, I didn't see you.
So much.
About to jump on the honor.
We have a number.
Better breaks it out.
All right, so we just need Mr. Pettis. And then at 11, hello,
Judge, may I approach?
yes,
Uh,
okay, no, I appreciate that.
No, this is. Judge, you have previously on this gentleman worked at Toyota and has been for some number of years. He is on a DWI probation for 6 years. You have that doc-
Mhm.
Oh, so it's,
Oh, if you have them pull the file.
okay. You do that.
Festivals. Festivals.
Just a, all the shocking.
Robert, you would appreciate this. This is what they've just delivered to us. Its thickness has increased.
Looks like a lot of law.
So it'll be,
We don't need no stupid law.
yeah, it'll be happy reading for me.
Bought one the other day, but it wasn't that bad.
Oh, yeah.
What's in it besides? Is it all the traffic codes? Just like. Let's cross it. Okay, I think got the governor, the water code. You would have to be out of convention. In case somebody brings that up.
Yeah. You know, the only thing that I read on a regular basis, of course, other than the new law, is the rules of evidence.
Have you done through this?
Hmm?
Have you done through this thing?
Oh, they just brought it this morning.
Doctor.
No.
Yes.
Yes.
How cute. Have you talked to the state in probation?
I have not. Is that what I should do?
Mhm.
So, well, here's what's going on. You denied the occupational license. I'm asking for reconsideration for 2 reasons. He's working at Toyota, has been doing wonderfully. He's been getting rides, and the guy that now has been his primary driver got switched to a different,
And so this will have to be set for a hearing
okay,
because there are new laws in place. So just speak with Ms. Ferguson about setting it for a hearing.
all right. Could there be some reconsideration?
Oh, I'm always open to reconsideration.
Okay.
But she'll need to set it for a hearing.
Then on a different young lady who just got out of Laurel Ridge, it's an MTR, and Hank and I agreed on a $25,000 bond. He's not here right now. I'm
She
waiting.
needs to be present for me to set a bond. Otherwise, it needs to go to Judge Nahara.
Okay, so she's out and about, so I bring her in?
Yes, to Judge Nahara.
Okay.
Good morning.
I
You need to file a motion, it needs to be signed by me. If there is an agreement, it has to say agreed.
Okay, on the bond.
On the bottom.
Okay, let's do this, Vincent Morris and the reconsideration. Right.
Yes, absolutely. Is it?
Um, Well, this is the CI number, but the criminal case is. It's 87-18-23. Absolutely.
Vashawn, will you have a chance? I will give you this document that's been sent to me, and it's a modification of bond conditions. All right. Do I have the paperwork on Brooks? His attorney is on Zoom. Mr. Brooks, if you can unmute, please.
Yes,
Have you been sworn in?
yes, ma'am.
All right, could I have a prosecutor, please? And I'm sorry, we're gonna go on the record, so you're gonna have to step back. Thanks. All right, court is calling 2023 CR 8191, State of Texas versus Ekali Brooks. Could I have the parties announced for the record for the state?
John Pettis for defense.
Just one second. I'm going to put you all in the breakout room. I've been told that your client hasn't signed 2 documents.
I apologize, Judge. I could have sworn we signed everything. I'll make sure we get that done.
All right, just give me one moment. I'm going to move you all to breakout room number 2. And once that's done, we'll take it up.
And then the victim's mom might want to be taken out of the breakout room to watch the plea. But just be
Okay,
kept on
all
mute.
right, I'll do that.
Yeah.
Well, I tell you what, if you ever want to, look, just let me know. Oh, no, I love this. And it took me a while because I used to, when I was a defense attorney, we had Connors and I got used to the way the Connors was set up. And so it took me a while to get used to this.
What will it say on the door?
Oh, that's awesome. You know what? It'd be nice if they had this and they laminated it.
Judge, question. Conferred with the state in regards to a bond condition. My client, Mr. Owens, wants to have his pet vaccinated. They don't have any objections to it. He's got a specific time and date when he needs to go. I don't know if I need to file a motion or if we,
Yes, if you do a motion and put your agreement in it, then
Okay.
I'll take care of it.
all right then.
So,
Thank
and
you.
you can just email that over.
Okay, thank you so much.
You're welcome.
Yeah, no problem.
And on John Meyer, we'll take that up right at 11, okay? So if they haven't signed their paperwork on this, we'll move directly into Meyer unless you all are, I think Hank is waiting for Mr. Stones.
Oh, yes, ma'am. Yeah, I'll text the judge.
Okay,
And I just need, I'm trying to set up right now on the PowerPoint. I don't think it'll take me long, but I'm wrong with form.
all right, yeah. All right, is it a PowerPoint for the actual trial or is it just a PowerPoint for this hearing?
The hearing.
Okay, sure.
I got it.
I'm sorry. All right.
756-798. Oh.
All right, so in the back, I just received the plea paperwork.
And Judge, on Brooks, nuance to it, I couldn't strike language in Adobe Sign, so, but I'll be waiving counts 2 and 3.
You'll be waiving which part?
Count 2 and 3.
Okay.
Yes.
Okay, just give me 1 second on that. Could I see the file on Brooks? Could you have them bring that file? Let me do this plea very quickly, and then I'll handle the matter with Frankie with her. Yes. Meyer. Let me see if I can find it. Ah, I do. Thank you. All right, on this, see if the state has any objections. I'm sure they don't. Yeah. All right, court is calling 2023 CR 8191, State of Texas versus Eli Brooks. Could I have parties announced for the record for the state?
Anna Ochoa Nelson.
Defense?
John Pettis for defense.
Mr. Brooks, if you can unmute, please.
Yes, ma'am.
And are you Mr. Brooks?
Yes, ma'am.
Mr. Brooks, I'm going to show you what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to plea by video conference. Going to show you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Brooks, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We'd like to proceed on count 1 and waive and abandon counts 2 and 3.
No objections, Judge.
All right, Mr. Brooks, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense in count 1 of sexual assault of a child? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am, I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Brooks, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State is proceeding on count 1. They're recommending deferred adjudication. There's to be Chapter 62 requirements and no contact with the complainant or the complainant's family. Did you understand that to be the plea?
Yes, ma'am.
Vince, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
I'd look at you and say that. All right. Outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 10 years and there be a TAP evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 1 in the indictment, how do you plead? Guilty, not guilty, or no contest?
I'm
Counsel,
sorry.
what
No,
are you recommending for the plea?
no,
Yeah,
Mr.
counsel,
Brooks, no contest, Judge.
no contact. Okay, I'm sorry.
are you
Yes.
entering a plea of no contest to count 1?
Yes, ma'am. I'm sorry.
No problem. Do you understand with the no contest plea, the court could still find there's sufficient evidence to find you guilty and find you guilty?
Yes, ma'am.
And do you understand the meaning of a no contest plea?
Yes, ma'am.
All right. State any evidence to support the defendant's plea?
State offers State's Exhibit 1 with attachments.
No
Mr.
objections,
Brooks,
Judge.
Oh, thank you. Mr. Brooks, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. right, after reviewing state's exhibits one and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt because you have applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right, so why should I accept this offer? Or this agreement, I should say.
Well, Judge, my client is my client will be getting help, obviously, through sex offender registration. This was a regrettable situation that he was placed in, that he placed himself in. After conferring with the state, we believe that this was a equitable response, and we know that he will be registered from now until forever. And he does want to show this court that he can be a safe and productive member of society, and that this incident is a sole incident and will never, ever happen again.
State?
Yes, Your Honor. We did come to this agreement with defense counsel. It is early on in the process. However, we did already meet with the complainant as well as meeting with her mother. As Your Honor knows, some of these pleas happen. We're fortunate to have this one happen early on to save the victim the re-traumatization and risk of going to trial on a case like this.
Okay. Mr. Brooks, can you raise your right hand for me, please? Do you solemnly
ma'am.
swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. How many children do you have?
3, ma'am.
What are their ages?
One's about to be 9, January 30th. The other one's 3, and my son is. I have two daughters. The first one's not about to be 9. The second one's 3, and my son is 8 months.
And are these children with you?
2 of them are, and one's in California, ma'am.
Which 2 are with you?
My 3-year-old and my 8-month-year-old.
All right, and they have the same mother?
Yes, ma'am.
And are you employed?
Yes, ma'am. I'm a manager at a hotel in Coeur d'Alene, Idaho.
Any alcohol issues with you?
No,
Have
ma'am.
you been drinking at all?
No, ma'am.
And I'm reading in the police report this was relative. It says in the police report cousins.
Some degree of cousin.
Okay.
Through marriage, I believe.
All right. Any other questions?
Nothing from the state judge.
All right, this is what the court is going to do. There's a $1,500 fine. That will be probated. What's the court cost in this, please? It's a second-degree felony. All right, the court cost in this matter is $325. Are you able to pay that in installments?
Yes, ma'am.
All right. There's a $1,500 fine, probated, Chapter 62 compliance, no unsupervised contact with minors, and that includes all minors. The court may change that in regards to your own children once you have completed some courses.
Okay.
He's to be with the sex offender unit. The only issue is you're in Idaho?
Yes, ma'am.
What county?
Kootenai County.
I'm sorry, what?
Kootenai County.
How do you spell that?
KOOTNAI. Sorry.
NAI?
Yes, ma'am.
And that's Idaho?
Correct, ma'am.
All right. So there's will be a transfer to Kootenai County, Idaho. 10 years deferred adjudication. Proof of employment with 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular UAs. And since he's going to be on the sex offender unit for probation, I know they do their field visits and everything, so there's no need for me to do that. And we can do a TAP evaluation out of custody. And because I did see that there was major alcohol or something involved in this case, there's going to be 90 sober meetings in 90 days. I would order you to have community service hours, but because of what you're charged with, there is no place for you to do community service hours. Probation, is there anything else? No. All right, anything else from the state?
Just the victim impact statement when we're done, Your Honor.
All right, defense, anything else with regards to sentencing from defense?
No, Judge.
Mr. Brooks, is there anything else you need to help you to be successful on this probation other than what I've given you?
No, ma'am.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we are off the record. Miss, it's my understanding that you are giving a victim impact statement. Is that correct? All right, I'm going to ask that you unmute yourself so we're able to hear.
Yes, ma'am, that's correct.
All right, you may proceed.
I'm going to go ahead and start with my daughter's victim impact statement.
Okay.
And it reads as, in February of 2022, by a family member. He was a cousin of my dad's side and his name is EK. After my incident, I had wanted to tell my mom. I was scared of what she would say or if she would believe me. When I decided to tell her, I wrote what had happened on a note and handed it to my mom. My mom just started yelling at me. She screamed, asking me why I didn't tell her. And she screamed at me and rushed me to grab everything I wore while I was staying at my aunt's and put it in a bag. Everything was happening so fast after I told my mom that I began to start feeling overstimulated. When we arrived at the urgent care, we signed in and took a seat in the waiting room. The environment felt very uneasy, witnessing individuals, criminals being escorted inside. It was a little past 1:00 a.m. when me and my mom finally got our names called just to tell us to come back at 8 o'clock in the morning for the next shift. Being on the hospital bed, getting examined, all of it felt very unsurreal. I had never been in that environment like that before. I had never felt uncomfortable doing that type of it. I felt uncomfortable doing that type of exam. I couldn't help but flinch and squeeze my eyes closed before the doctor started the exam. I remember at family events, I began to feel uncomfortable around my uncles and my mom's male friends. I started not wanting to be around people who had been there my whole life. My support, my comfort level had been non-existent now. Not too long after the incident, I had begun to have frequent anxiety attacks to the point of hyperventilating. The episodes had become so frequent, it became a disturbance at school. causing my mom to talk to the teachers about me having the option to leave class when I need to leave class when I needed to in order to talk to the counselors. These episodes were at random, with my heart rate going up to 195 and 200. Having a therapist, getting some of the stress off by talking to her. Having to talk to her about the situation was hard to think about, but I was so worried that if my therapist didn't get enough information, then everything would have been for nothing. While talking about the situation, it helped work to an extent, because then she started having nightmares. One time in the middle of my nightmare, I woke up and realized I had peed in my bed. I felt so humiliated. About having peed on myself as if I was a child. I felt like I had no control of my body or rights or free will. I didn't trust men, classmates, or close people to me anymore. At one point in my life, it just felt silent, as if I was on autopilot. My mom was calling the DA's office every week on the DNA. One evening when I came home, my mom had told me the results came in and it had no trace of anything. I was in such shock and anger because you know what happened. I felt as if the test scores invalidated me and brought me to believe there was no way this man was going to get what he deserved. Seeing my mom go through the process of this case is also very painful. Ever since she had found out about what happened, I would see her crying for me and blaming herself. I always tried to assure her. Sometimes I will still see her and catch her crying. The incident not only affected me, but my relationship with my mom's family and dad's side of the family. My Aunt Maria and Aunt Sally were very hard-headed, but when I told them, I thought they would still understand. Instead, they broke contact with me, became defensive when my mom would try and talk to them. My Aunt Sally just thought I was lying and continued to text however, she continued to text her brother Antonio. Although on my dad's side hasn't talked to me, she still has her brother. I believe that when they shared with me that they had also gone through this of being sexually assaulted, through their experiences, they would have understood. I haven't spoken to them since the incident. However, my family on my mom's side was also affected by this. In the beginning of this report, I wasn't sure how fast things would progress, but I knew I wanted support from my mom's side of the family. It took me a while to find the right time to tell them. but when I did, the reactions were nothing close to what I would have thought. My uncles and aunts restricted me from spending time with my cousins at family events, claiming they didn't want me to think something is going on with my cousins. It wasn't until they started talking and including me and my mom. This incident has affected me in long-lasting ways, corrupting my family relationship, trust, especially diminishing my sense of security. Judge, I thank you for giving me the opportunity to submit the victim impact statement on the behalf of. I did want to include just some of my information to EK.
All right, thank you so much.
Can I mention?
Yes.
Thank you. There are so many questions, and I wrote this down so I can stay on track. And I know there are so many questions I have for EK, but I will never get the answers. I do remember his father, Senior, and Aunt Maria wanting to move back to San Antonio after EK retired from the military. He was a military police officer in the Navy and wanted to join local law enforcement. Instead, he studied to become a pastor. I remember EK and Aunt Maria telling me that you, EK, had moved back for a while, hopes in getting on your feet because you had ran into some trouble where you were previously living. I remember the day Aunt Maria asked when Angelica wanted to attend the church retreat for teenagers, and because your father would also be there. Plus, I was working a part-time job at the rodeo, so this was convenient. Angelica wanted to go because as young teens search for themselves to identify themselves, so was Angelica. You were present during our discussions of hard times she was having at school. You knew what she was going through. I knew you were living there, but I never imagined that you would take advantage of my baby while she was staying that weekend. You are aware that her father was murdered, and all she had was her aunts, your father, and her brothers. We had just celebrated her quinceañera. She was
All right. I don't know what happened. I think we may have lost her. So if she zooms back in, we'll continue. All right. So Mr. Brooks, I'm going to put you and your attorney in a waiting room. I don't know, something happened. So I'm going to put you in a waiting room. And if she comes back on, I'll zoom you all back into the main room.
Thank you, Judge.
You're welcome.
Thank you.
Will you put me in that same one?
Yes. I will put you, well, let me put him. I'm going to move you to breakout room number 1, and I'll move them to number 1. And are we ready on Meyer?
Yes, ma'am.
Oh, you're welcome.
We don't need anything else.
All right, we'll do.
Oh, I was saying, what?
Yes.
We're all there. That one thing I had was, I think I've got a clicker. Got a clicker. That's it. No.
All right, court is, John, are you ready? Court is calling 2024 CR 0170, State of Texas versus John Stephen Meyer. Can I have parties announced for the record for the state?
Hank Wilkins and Kevin Stone for the state, Your Honor.
Defense?
Charlie Baird and Mark Stevens for John Meyer, Judge.
All right. You all may have a seat. And so there are two issues we need to take up, and both parties told me, at least Mr. Stevens informed the court it would be 10 minutes.
Whoa,
He's,
I'm joking, Judge.
he was like, Judge, could we not come in at 11 because it's only going to take 10 minutes? So
I don't think,
should I hold you to that?
if you will not hold me to the minute and the second, I'll be quick though. Judge.
Okay, no.
Relatively speaking, can I say?
yes. All right, the first issue, I'm sorry, Ms. Abrams. All right, where is she? All right, I put her in breakout room number 2, but if she logs back in, I'll put her back in. All right, the first issue we have is there is a motion to suppress. I think we should start with the easiest one first in my eyesight. There's a motion to suppress the defendant's statement. Is that correct?
Yes, ma'am.
Like off the record for a moment, Ms. Abrams? Have you had a chance to go into breakout room? Oh, okay. All right, thank you. All right, so the first we have is a motion to suppress, and it has to do with the defendant's statement. Is that correct?
Yes, ma'am.
All right, so yesterday, the state and the defense both presented the court with a DVD video of the defendant making a statement. Is that correct?
Yes, ma'am.
All right.
Yes, Your Honor.
So the court had a chance to review that. If both parties would like to call witnesses, you're more than welcome to call witnesses. I believe I know what the issue is as stated by the defense with regards to that statement. If there are no witnesses, I will make a ruling on that.
Judge, I have Officer Salazar here who
Okay.
reads out the warning. I don't know if you want to hear from him or you feel like we need witnesses.
No, if you all want to call him as a witness, you're more than welcome to call him as a witness for that. But from the court's perspective, from what I saw in the DVD, the rights were read to 4 individuals who were in the room. From what I saw and what I heard, and if I'm incorrect, let me know, the defendant in this case never responded in the affirmative or the negative that he understood his rights. Is that correct?
Yes, correct, Judge.
He just started answering questions. Am I right in that rendition?
I don't think he ever says anything, Judge. He just starts responding to questions.
Yes. All right. So I'm assuming the officer is not going to say anything differently than what I've seen on the video. Is that correct?
Yes, ma'am.
So if there's no objections from the defense or the state, for purposes of the record, if you all would like to offer the DVD into evidence for this hearing, and then I will make my ruling in regards to that.
Yes, ma'am. We would like to offer the record. I guess since it's our motion, we're
Yes.
meeting to sponsor the exhibit. Can we have that marked as perhaps defendant's pretrial 1?
Yes.
And you have that, I believe, physically?
No, they
or
have
in the
it.
back?
Yes, sir.
Okay.
Do you want to?
We have a sticker, Judge.
Sure.
And it was to be marked as defendant's PH1 instead of PH1.
Yes, that's fine.
Or PT if it's.
One second. Charlie, what are we calling it?
PT1.
PT1. Okay.
And with that, Judge, this is
video.
has been provided to us by the state, so I don't give any authentication problem, and we would offer defendant's PT number 1.
Yeah, no objection, Your Honor. I will, this is the partially muted copy, Judge, so it's muted as to everyone except for the officer and the defendant. And then the other officer who's actually holding the camera says like taping at the beginning of it, but I think that's the only other voice you're gonna hear. You're not gonna hear any of the other folks who are there.
All right, so everyone, make sure, one, you can remain seated. Number two, if everybody can keep your voice up, so it's easy for the court reporter to hear and easy for me to hear because my allergies do not like this weather. All right, so without objections, defense exhibits, what label did you give it?
PT1.
PT1 is admitted. Court has reviewed PT1. And it was the muted version that was presented to the court. Both parties are aware that the court reviewed that exhibit. With regards to the exhibit, is there any brief argument that either side has? I believe the defense is aware and the state is aware that the state has the burden to show that the defendant understood his rights. So if anyone wishes to speak to that, you can. I'll hear brief argument.
Sure, Your Honor. So the code says that substantial compliance with the warning is sufficient. And so we believe this, the warning that the defendant was read was either the exact wording required by the code or it was substantially compliant with that. The code also says in the cases that have interpreted the code, say that either that express waiver of the defendant's rights is not required. And that case is, I mean, that's Miranda, I'm sorry, Joseph v. State, which is 309 Southwest 3rd, 2020. That's a CCA case. And waiver can be clearly inferred from the actions and words of the person interrogated. So Judge, the state's position here is that the defendant was read his rights. The questions that were asked were that he responded to were the officers asking questions for their own safety. Hey, is there art? I believe the officer asked, are there any booby traps or anything in the house? So when we're searching the house, is anything gonna hurt us? And so I think the defendant made this statement like, hey, there's a gun there, and that might be something dangerous that you might need to know about. I think he made that after being informed of his rights. I think that should be admissible, Judge.
All right. Defense.
Judge, we believe that once the rights were read, clearly he's in custody. Once the rights were read to Mr. Meyer, there was no indication on this exhibit that he understood those rights or that he intentionally, knowingly, and intelligently waived those rights. The officer provided the rights to Mr. Meyer and then immediately began the question. And I think the law is clear that if the questioning is likely to elicit an incriminating response, then it is prohibited in its admission by Miranda and its progeny. We think that's very, very clear. There is no indication here that there was an intelligent, knowing, and voluntary waiver of those rights before Mr. Meyer responded to the interrogation and the question of Officer Salazar. And therefore, we don't think it can be rationally inferred from the exhibit before the court at this time. And we would ask that that statement be suppressed.
All right. Now, the next issue, and I'll make my ruling in just a moment, but the next issue we have is the issue in regards to the search warrant.
Okay.
Right. And defense is asking that the granting of the motion to suppress, which was signed by Judge Jansen, that it be suppressed, correct?
That is correct.
All right. And both parties tendered to the court yesterday the affidavit for the search warrant and also tendered to the court the actual search warrant as well. So the court has reviewed those two items. And also the court has reviewed the case law and the memorandum that was provided by the defense. So with regards to the affidavit for the search warrant, in the actual search warrant. Does anyone wish to offer that into evidence for purposes of the hearing?
May I approach and do just that, Your Honor?
Yes.
And we labeled them A and B yesterday. but
Yes.
To keep it in sync with how we started. PT2, Your Honor, is the affidavit for search warrant issued by Judge Jansen and the affidavit was Deputy Wolf on August the 8th, 2022. That's
Yes.
PT2, Your Honor.
All right. Oh, if you'll pass it to the court reporter.
Your Honor, PT, Defendant's Exhibit PT3 is the search warrant itself, signed by Judge Jansen on August the 8th at 4:15 p.m.
All right. Thank
No
you.
objection, Your Honor.
All right. Then PT2 and PT3 are admitted into evidence for purposes of this hearing only. And I know that both parties are aware that the parole evidence rule applies. So it's just the four corners of the document. So unless there's witnesses that anyone wish to call, I'll hear argument.
Thank you, Your Honor. Mr. Wilkins informed me, he helped me get this up and he's willing to help me keep it going now. Thank you, Hank. Your Honor, our suppression argument, of course, is based on the 4th and 14th Amendments to the United States Constitution, Article 1, Section 9 of the Texas Constitution, and Article 38.23 of the Texas Code of Criminal Procedure. As the court noted, this is a four corners argument, and I suggest to the court that I have roped off the meat of this affidavit. That's it. Everything else is just uncorroborated, unsubstantiated, and unpersuasive boilerplate. But this is what it comes down to, Judge. So I'd like to go through this as quickly, and it won't take long, but quickly, but line by line if I can. So it says, affiant received information that narcotics were being used and possibly trafficked from 224 Majestic Grove. We submit that nothing in this affidavit would cause a reasonable person to believe that narcotics were being used and possibly trafficked from 224 Majestic Grove on August 8th, 2022. We go on to suggest to the court and argue to the court that if the court looks, as the case law requires, at the totality of circumstances, does this affidavit give a reasonable, neutral, and detached magistrate a substantial basis for concluding that there's a fair probability that the drugs are in the place they're said to be? And the answer to that, we think, is no, Your Honor. So just on that first sentence, was this information, it says I received information, was it from a known or an anonymous tipster? That makes a difference to the credibility. But there's no mention at all of whether it's a known tipster or whether it's anonymous. And there's no reference to the tipster after that. And I call the person a tipster. I don't even know if it rises to that level. Was the person providing the information credible and reliable? This, of course, is the two-prong test that was not overruled, by the way, by the Gates decision. In fact, the Gates case said we still regard these two factors as especially important. However, the court went on in the Gates case to say, but they're not everything. They're not the be-all, end-all. There can be things that perhaps corroborate the tip beyond credible and reliable, but there is no mention, there is no suggestion. And Your Honor, I say with no hesitation, this is the most insubstantial affidavit I've ever seen. I've never seen in Bear County, at least the boilerplate language, not alleged, credible and reliable. Had this person, whoever it was, given true and correct information in the past concerning narcotics? So that's the basis of the information test. What was it that caused the person to say that narcotics were being used and possibly trafficked? And I have to say, what a strange way to put that is. Somebody says, I have information that they're being used and possibly trafficked. How reliable is that information just on its face? But had the person ever, no, there's no evidence. There's no reason to believe that the person had ever given true and correct information in the past. Whoever this was, that's again, just boilerplate stuff. Did the person have any known ability to identify narcotics? So that's always said. I rely on a credible and reliable informant who I've used in the past and who's given reliable information and knows how to identify the drug in question. By the way, what type of narcotic is it? That makes a difference.
I have a question for you, counsel.
Yes, ma'am.
And so that, people always say as little as possible, right? When you're a judge. I don't believe in that because I want the communication to be open so that I can let you know what my questions are. So maybe you can address those. So I understand what you're saying about the credible and reliable informant. I do. But it appears from my reading of the affidavit that they're saying, you say it was a tipster. They're saying that somebody informed them that there were drugs at this location. And they're saying that, so what the police did, according to the affidavit, I'm going strictly with the four corners. I'm not going outside the four corners, is that they see someone by the name of Melissa Yanez exit the location, leaves, travels about 100 feet, comes back to the location, and then leaves the house with a black rectangular or dark rectangular bag or box, gets in her vehicle, leaves the location with that box. They perform some sort of a traffic stop, ask her, according to the four corners of the affidavits, to search the vehicle. She says no. They bring K9 out. K9, they say hits on positive for drugs. And the positive for drugs is from that black box. They open it and they say there are drugs there. So I understand what you're saying about the credible and reliable informant, but my question is, if the police are surveilling a house and it appears they're basing their search warrant from the four corners upon what they saw at the house, do we still need the credible and reliable informant for an officer to sit on a house and watch a house?
Not necessarily, Judge. However, I think it's given what else we have. In other words, many of the cases talk about the credible and or the tipster, informer, whomever, and how it is corroborated.
Okay.
And I think we fail in both counts. So I think, and I think Gates says this too. If you're weak on the two-prong test, you can strengthen it and cure it perhaps with adequate surveillance, or vice versa. But here we have neither.
Okay.
I'm happy to go on because I think I'd like to address some of the questions, and I think I do. But if the court has, please interrupt me anytime, Judge.
Thank you.
I want to know what the court cares about.
All right. Thank you.
Did the person see? I'm still on the informer, Judge. It's not an informer. It's a person. That's how that person is identified. Did the person see the narcotics being used in possibly traffic? So it goes to the basis of their. What were the narcotics? It does make a difference, Judge. Some narcotics are legal and can be prescribed. Morphine, for example, or other narcotics can be prescribed. So just because you saw narcotics, and most search warrants, it may seem like a quibbling thing, but most search warrants will say it's contraband per se. It's methamphetamine or it's cocaine. It's something you don't have a right to have no matter what. Doesn't say here. How much narcotics is hugely important because if they had said a large quantity, a deliverable quantity, then perhaps someone could infer that it's going to be there for a long time or that it's valuable. We don't know how much it was because the affidavit doesn't say how much this person said was being used and possibly trafficked. Who at Majestic Grove was using and possibly trafficking the narcotics? Interestingly, this affidavit says that the premises are under the control and charge of Melissa Yanez. And it says, and John Meyer occupied the premises. Now, there's no source for that information, by the way. That is wholly alleged by the affiant without anything like, I checked the property records, I checked the tax rolls. Nobody corroborates that who's in charge of the place and who occupies it. When did this is very important, Your Honor. When did the affiant receive the information? It doesn't say. So did the affiant receive the information 3 days before, 1 day before, 1 year before? I don't mean to get too off the planet, but it ought to be easy enough to say a month, maybe. I mean, give us a month, give us a year, perhaps. It doesn't say month, day, year, or time. How much time passed between the time the affiant received the information and did they set up out there? The reason that matters is because the more time that passes, the less there's going to be of some unknown quantity of an unnamed narcotic. And this is also big, Your Honor, and it's related. When were the narcotics used and possibly trafficked? As the court knows, the language we always see is informant, the credible and reliable informant did see cocaine on the premises being used by a particular person within the last 48 hours. Doesn't give us a time frame at all about that either. So then we get to surveillance, Your Honor. What did they do to corroborate? Basically, what I suggest is nothing. What did they do to corroborate that? We say they did nothing to corroborate that information. So how much time elapsed between August 8th, 2022, the date the warrant was executed, and the date when the narcotics were allegedly used? That's what I just talked about. And it says here, affiant observed Yanez exit the residence and depart in a black Jeep, blah, blah, blah. Affiant, the court saw this. The court already said this, exactly. Entirely innocent behavior, by the way. You leave your residence, you go 100 yards and you come back and you get some item. By the way, what item was it? Dark rectangular bag or box. That's again, that's not trivial because later on they say that the item found in Yanez's car matched the description, but a bag is different than a box, and a dark rectangular bag is different from a dark rectangular box. So one thing only to bring up there. A probable cause traffic stop was conducted. Sure, that's right. But this is absolutely crucial, Your Honor, when you're talking about the value of surveillance to corroborate an event. How much time passed between Yanez's departure and the traffic stop? Would it have been easy for the officers to say, we saw her leave at a particular time? We don't have that. Doesn't say. We tracked her. We followed her. We didn't lose contact with her. We followed her until the traffic stop. Doesn't say that. It doesn't even say conclusorily that they followed her until the stop. It doesn't give a time. So did Yanez drive around for an hour and a half? Did she stop at 5 different places before she was pulled over for the probable cause traffic stop? We don't know that. And that's important because they're obviously trying to make some link between the drugs found in her car and the drugs that she left with, that they're trying to suggest it came from 224 Majestic Grove. But how do we know that? How do we possibly know whether any quantity of drugs was in that bag or box, or what drugs or what quantity? Because we don't have continuous surveillance. We don't even have the allegation of continuous surveillance. We just don't know. Now, was Yanez observed continuously from her departure until the stop? Easy enough to say if it were true, but it doesn't say that here. Did Yanez go? Where did she go before the traffic stop? Again, questions that are unanswered by that affidavit. Then the canine arrived and hit on the vehicle. So this is what I said just a minute ago. The box matched the description. Well, it didn't, Judge. It didn't. Surveillance gave us nothing. So they say they conducted a local criminal history check on Melissa Yanez, not on John Meyer, but a check on Yanez, and found that she has a prior arrest in Bexar County for possession. Didn't say when it was, and we know her date of birth and her SID number. So that adds nothing at all to their case, Your Honor. This is another something. I'm going to go back sort of to the top of the affidavit, though, where I mentioned this a minute ago. It says the premises are under the control and charge of Yanez and occupied by Meyer. But the affiant does not even claim that this conclusion came from information provided by the unknown tipster. We don't know where he got that information. The unknown tipster said narcotics and not methamphetamine. So again, this is an unsourced claim that it is a place where a controlled substance, to wit methamphetamine, is unlawfully possessed. So that's all just uncorroborated, unsourced statement from the affiant that is not supported by whoever his tipster was, who just called it narcotics. That's their affidavit, Your Honor. Given the complete lack of information about the credibility and reliability of the source, about the unknown lapse of time between when she departed and when she was stopped, no reasonable, neutral magistrate could have concluded that the methamphetamine in her vehicle came from 224 Majestic Grove. And even if one could make that conclusion, and I suggest one could not, what would give a reasonable, neutral magistrate probable cause to conclude that there was still methamphetamine at the residence at the time the warrant was issued, given that the information was there was an unknown quantity of narcotics being used and possibly trafficked at the location. Just a few of the cases which we've cited in our memo. The core of the Fourth Amendment warrant clause, Your Honor, says that the magistrate may not issue a warrant without first finding probable cause that a particular item will be found in a particular location. We don't have a particular item here, and we don't have a particular location. The test is whether a reasonable reading of the magistrate would lead within the four corners to provide a substantial basis for issuing the warrant. Totality of circumstances, is there a fair probability, not a possibility, Your Honor, is there a fair probability, and is there a substantial basis for that, that evidence of a crime will be found at the specified location? That's Duarte. Schmidt says, the facts submitted to the magistrate must be sufficient to justify the conclusion that the property that is the object of the search is probably on the premises to be searched at the time the warrant issues. Again, given the lapse of time, the scant information provided about quantity and about the substance, how would a magistrate have any basis for concluding that when they went there, when they signed the warrant, when the judge signed the warrant at 4:15, that there would be some illegal narcotics at the location. There's a case called, and the Schmidt case said this, the affidavit in the instant case fails to state when the affiant received the information from Bell. That's exactly our situation here. And if we assume that Bell is the person who informed the officer, or when Bell obtained his information, exactly those three things we are also lacking in ours. There is nothing in the affidavit to demonstrate when the incident it describes took place. This is a Johnson case. The affidavit in the instant case establishes that a specific offense was committed by appellant and that the items sought were evidence that appellant committed the crime. However, the affidavit in Johnson did not give probable cause to believe that the items sought would be located at appellant's apartment. Absent these underlying facts, the judge was unable to make that independent interpretation, and the evidence was ordered suppressed by the Court of Criminal Appeals. Lindley is a case that cites Johnson, and it says probable cause to believe a person has committed a crime does not automatically supply probable cause to search that person's home for evidence. If it did, Your Honor, think about it. I've never seen the police go to somebody's house after an arrest or get a search warrant just because they arrest somebody on the street. There has to be something in addition to just the fact of their arrest. Otherwise, we wouldn't need to distinguish between an arrest warrant and a search warrant. And Casillas, Casillas is a case we gave the court and we cited, where the facts indicate that arising from a reasonably trustworthy source would warrant a person of reasonable caution to believe that evidence may presently be found in a specified place. There is probable cause to issue the warrant. This is premises under control. I talked about that earlier. The Casillas case also says that. In Casillas, the affiant merely asserted that the premises were under possession and control, but that is a purely conclusory statement, the source of which is not given nor the reliability vouched for. Same here, Your Honor. That's what we have, Your Honor.
All right. State.
Yes, Your Honor. Can I approach? I have a case. I've provided this to defense. Mr. Over.
Thank you.
So Judge, since there's a warrant in this case, the burden is on the defense to prove the invalidity of the warrant, and we don't believe they've met that burden in this case. The test is whether a reasonable reading by the magistrate would lead to the conclusion within the four corners of the affidavit provide a substantial basis for issuing the warrant. Probable cause exists when, under the totality of the circumstances, there's a fair probability that contraband or evidence of a crime, will be found at a specified location.
All right, let's do this. If you can start back over.
Yes, ma'am.
With your section that you're reading.
Yes, ma'am. So this is from Duarte, Judge. So the test is whether a reasonable reading by the magistrate would lead to the conclusion that the four corners of the affidavit provide a substantial basis for issuing the warrant. So probable cause exists when, under the totality of the circumstances, there's a fair probability that contraband or evidence of a crime will be found at the specified location. And then this is also from Duarte on the next page at 355. After reviewing the supporting affidavit realistically and with common sense, a reviewing court must uphold the magistrate's decision so long as the magistrate had a substantial basis for concluding that probable cause existed. The focus is not on what other facts could or should have been included in the affidavit. The focus is on the combined logical force facts that are in the affidavit. So the fact that there's some behavior in the affidavit that could have been innocent, that doesn't defeat probable cause, Judge. So the question here is, did the magistrate who issued the search warrant have a substantial basis for concluding that probable cause existed? And we're saying that he did, she did. So the Casillas case that defense just mentioned, the quote from that is, the probable cause to support the issuance of a search warrant exists where the facts submitted to the magistrate are sufficient to justify a conclusion that the object of the search is probably on the premises to be searched at the time the warrant is issued. So, Judge, just from that case I just gave you is Flores v. State. And the reason I gave it to you is that the court goes through, here is what's in the affidavit. So I just like to go through that. I know defense has gone through that, so this is a little bit cumbersome here, but in the affidavit, it states, Brian Wolf has 20 years of experience with BCSO. He has extensive experience with arrests for narcotics violations. He's thoroughly familiar with the information contained in the affidavit. Wolf believes that a place Melissa Yanez has control and charge of and occupied by John Meyer is a place where methamphetamine is possessed. Client received information that narcotics were being used and possibly trafficked at 224 Majestic Grove. Client conducted surveillance on 224 Majestic Grove on August 8, 2022. The client observed Melissa Yanez exit 224 Majestic Grove and enter a Jeep and travel about 100 feet, then turn around and go back to 224 Majestic Grove. And I think that part's important, Judge. Yanez then went back into the house and then left holding a dark rectangular boxer bag, enter a Jeep with a certain license plate, and depart the address, 224 Majestic Grove. Within the affidavit, it states that Yanez is stopped for a traffic violation. A canine arrived and conducted a free air sniff and alerted on the vehicle. A black rectangular box was discovered in the vehicle, which contained over 300 grams of meth, packaging, and a digital scale. The substance field tested positive for methamphetamine. The box matched the description of the object that the affiant observed Yanez carrying when she exited 224 Majestic Grove. Based on the information provided by the affiant and verified through the investigation, coupled with the affiant's training and experience, the affiant has reason to believe and does believe that Melissa Yanez is in unlawful possession of the above described controlled substance to wit methamphetamine. So this Flores case, Judge, so that's just what's in the affidavit. That's just what's within the four corners. This Flores case, Judge, which is a CCA case from 2010, it says that the magistrate could directly find facts from what's in the affidavit. So based on the facts just within the affidavit, the magistrate could directly find that Wolf is a longtime peace officer with extensive training and experience in narcotics investigations. The magistrate could find that Wolf, in the course of his career, has observed methamphetamine use in transactions. The magistrate could find directly from the facts in the affidavit that Wolf conducted an investigation that led him to believe that Melissa Yanez and John Meyer live at 224 Majestic Grove. That Wolf received information that narcotics were being used and possibly trafficked from 224 Majestic Grove. That Wolf conducted surveillance on 224 Majestic Grove on August 8, 2022. That Wolf observed Yanez leave 224 Majestic Grove, enter a Jeep, travel approximately 100 feet, then return to the house and exit the house carrying a dark rectangular bag or box, then get back into the Jeep and depart the location. The magistrate could also find from the four corners of the affidavit that Yanez was stopped for a traffic violation after leaving 224 Majestic Grove before she stopped anywhere else. And the reason I think that's a reasonable thing that the magistrate could have thought is it's in the affidavit that she leaves, travels 100 feet, and then goes back to the house. It doesn't say, and then she stops somewhere else. That's the only stop that's mentioned in the affidavit, Judge. I think that leads credence to the reason that's a reasonable assumption. Yanez denied permission for the officers to search her vehicle. The canine then came and did a free air sniff and alerted on the vehicle. And then over 300 grams of meth, a scale, and packaging were located in the same black rectangular box that Yanez had left the house with. So our position is the anonymous tip, coupled with an experienced officer's observations during the surveillance, and the traffic stop revealing the drugs in the container that Yanez left the house with, gave the magistrate a substantial basis for concluding that illegal drugs would probably be found in the premises. But this Flores case, Judge, also says that from the facts that we just went through, the magistrate can make reasonable inferences. So the magistrate could have inferred that the information Wolf received was reliable based on Wolf's observations and Yanez being pulled over with 300 grams of meth.
Okay,
Yes, Your Honor.
all right. So with regards to the motion to suppress the search, the court has heard enough information and case law from both parties. But if you all would like to continue with more arguments, of course, I'm willing to hear it. And I know defense is your motion, so you have final argument.
Judge, I always hesitate to talk when the court says it's heard enough. But I do have a response to the Flores case.
All right, you may respond to the
Uh,
Flores case.
Thank you, Judge. It's completely different than our case.
Mhm.
In Flores, there was a tip by someone with some familiarity of the defendant and his affairs. Not here. In Flores, there were several details from the tip that were corroborated later, which the court found significant. Not here. In Flores, totally different than here. The tipster said she had observed cocaine in the home. Again, that's the basis for the information that is totally lacking here. But the crucial facts in Flores are two, I think. One, that in order to corroborate the information, the diligent police officer went on March the 1st and searched the garbage can right in front of the Flores home and found marijuana residue, seeds, and stems. But that wasn't enough. He went back on March the 5th, the day before the warrant was issued, went back again and found more residue, seeds, and stems in Flores's garbage. And the court said, the doctrine of chances. What chances are that if we come to your house with a search warrant looking for marijuana, and based on this information, including the fact that the officer went out not once but twice, what are the chances are that somebody will dump marijuana in your trash can on 2 different days? And the court says, not really. I was surprised, Judge, when Mr. Wilkins said that because somebody surveilling the person at the scene saw her stop within 100 feet, that's good enough to believe she didn't stop at all anywhere else. I don't think so. And finally, I'm really glad he did cite the Duarte case, because that was our case. I have a copy for it, Your Honor.
Oh, sure.
Could I bring the court a copy of Duarte?
I'm aware of the case, but I always love to have copies.
Thank you. The important part about Duarte, of course, is that the Court of Criminal Appeals affirmed the trial court and reversed the Court of Appeals. The trial court granted the motion to suppress. It went up to the Court of Appeals, which reversed, and the Court of Criminal Appeals, not known always as a friendly court to the defense arguments, nonetheless said this affidavit was insubstantial. It contained insufficient particularized cause about the alleged possession. And the language that I think is particularly important from Duarte that mirrors our deficient affidavit is found, Your Honor, on page 359, but it's on page 7 of that Westlaw version. And it says this: the tip was firsthand observation. Okay, that's more than we had here, but it contained no particular level of detail. The tip was, and the court said that he was the credible informant, stated he had observed Duarte in possession within the past 24 hours, far more than we have here. But then the Court of Criminal Appeals said this: that is it. How much cocaine did he possess? A couple of lines worth, laid out at a party and fully consumed? A kilo? Where did Mr. Duarte have the cocaine? In the pocket of his jeans? Hidden in the attic? Was it piled on the kitchen table, being weighed and packaged for sale? This is not a case where there is a tip about methamphetamine lab or marijuana growing operation or crack cocaine dealing. In those cases, the tip supports an inference that the criminal activity is ongoing. Not here, not in Duarte, and that's our argument.
All right, thank you. So what we're going to do is we're going to come back at 1:25 because the court reporter needs a break and everyone needs a lunch break, really. So we'll be back at 1:25. At 1:25, I'll make my decision at, if, of course, if it's to deny it, then we'll be done here. I'm sorry, if it's to grant it, we'll be done here. If it's to deny it, we'll continue with our jury trial. So the jury has been told to be here at 1:30, and if you all come back earlier than that, I'll make my decision. So 1:25. All right, thank you.